now onto something entirely different, but also very relevant. Because sometimes when we think of social sciences and academics in general, we believe that we have to talk in an intellectual way that has to be technical and confusing and boring. In that spirit, we thought, who better to invite than someone whose work has been described as poetic sometimes. Although he writes judgments, they have been accessible not only to the elites who read newspapers, but also activists and citizens who have struggled for a right to the city. And I think there is no better person to speak on this topic than our guest today, Justice S. Muralidhar.
So today when we plan infrastructure for courts and court buildings, a major portion of that would be for preserving paper. So there were three basic management strategies. We decided to adopt the free and open software system, and then we developed what is called the core and periphery model for software development. We have what is called the litigants charter. Basically the basic idea of computerization is to make it easier for the litigant, make the court more accessible, more easy to access information on cases. Once you're not sure how well you're going to use technology, you're hesitant to use the funds to obtain more technology. So all this meant that there was a return of monies unspent to the government by the judiciary because of these issues concerning hardware and software. We now have a case information system, and this is called CIS 3.1. And if you go on the net and type out what is called National Judicial Data Grid, the NJDG, you will find enormous granular information on district courts. They can upload real-time data on the actual service of notice by taking a photograph of the affixation of notice or delivery of notice to the person, and the report therefore is available to the court instantly. Many of the so-called tariq pe tariq that you've heard of happens because of this one delay, when the court is not told whether the notice has been served or the notice has been returned unserved. When the court has to again issue that notice, the case gets postponed by another 3 months, then another 6 months, another 10 months. And that's how cases get delayed. We've also shifted to cashless payment in courts. This has happened for the last 10-15 years now. We also have virtual courts now. You must have seen that apart from live streaming of proceedings, you can participate in courts through video conferencing. We have automated emails. Today, if you are a litigant in a court and you have a lawyer too, if you give both your mobile numbers to the court system, it will automatically generate messages to you so that you know which is the next date in your case, what is the order passed in your case. The idea of a virtual court is not that it's not like an online dispute resolution. It does mean that there will be a judge in even this virtual court, but you don't have to be physically present before the court. So we've had cases in the Delhi High Court saying, is there a way you can anonymize all of this? The problem is these judgments are already on the net. And how do you now anonymize something that is already been there for 5 years and 10 years? Basically, a judge needs to know how should he or she schedule the cases. Which cases deserve priority, depending on the category of cases, right? There's one category called senior citizens who are waiting in the court, maybe for a pension or for resolution of a family dispute, and they've been waiting for 10 years. Then you say senior citizens deserve a priority. Then there are women waiting for maintenance from husbands who've driven them out of their marital house. So how do you prioritize them? Then you have persons in jail who have not got bail for the last 5 years and 6 years. The trial is inconclusive. How do you prioritize their cases? We've introduced a system of e-filing, which means you don't need to physically go to the court to file your cases. You can file it from wherever you are. And the attempt is to make this easier and easier. And then we have live streaming of cases. Today you can see the court hearings, not only the Supreme Court of India on constitutional cases, but you can also go and watch the proceedings in the high courts of Karnataka, Madhya Pradesh, Orissa, and many other courts in the country. We have e-Seva Kendras in most courts. This is to bridge the digital divide. There are many people who still cannot access a computer, a laptop, a tablet, or even a smartphone. So for such people, and some lawyers also are not able to afford these things. So these e-Seva Kendras are meant to help you utilize this huge electronic infrastructure to file cases, to track your cases, and to follow up on the cases.
Have there been any sort of external security audits or attempts at standardization to ensure, that people's confidential details are secured? And like, could you elaborate upon that if you're aware?
Yeah, one is that we don't have internet connectivity in that RRDC. And we have backups, we have 3 backups stored in 3 different locations. So we're constantly reviewing even our, security measures. And that is built into the system, the audit of the security measures. So again, that's a work in progress. We want to adopt the best practices elsewhere.